We're going to talk about financial rules and rent controls. Now, thankfully, Labour didn't bring in rent control, so that is one piece of good news, because that was being talked about when the government became red, and that is not going to be a problem. But what we do now face is a restriction on the amount of rent in advance that we can take. They took a tenant with 12 months rent in advance who turned out to be the tenant from hell. So you should always be cautious when tenants turn up with a big stack of cash and say, don't reference me, move me in. Some people have genuine reasons, like they're moving back to the UK from overseas. Quite often we have areas where we rent to Hong Kong nationals, or a lot of nationals are coming over because they have no credit worthiness here. They would pay rent in advance. But as of the 1st of May, all of that's gone. We're not going to be able to take any more than 1 month's rent in advance. There is a caveat to that, and it's up to you whether you go down that route. So what they're saying is you cannot take any more than 1 month's rent in advance unless the tenant offers it. Now, you are going to have to prove that the tenant offered it and you didn't make it a condition. We have to make rules, processes, procedures within our business, within our agency. And my rule is we're just not going to take it because it's just not worth the risk. Unless there is an express, absolute reason, like I've just stated, I'm a Hong Kong national coming over back into the UK, or whatever the case may be, and I would like to offer rent in advance on this property. It's got to be watertight, otherwise we will be held liable. You will be held liable. Now, another little new thing that's coming in with the renters' rights, which again, I completely disagree with, and I don't know how we're going to police or manage this, is that you cannot request rent until the tenancy agreement has been signed by the landlord and the tenant. So if the tenant fails to pay you the first month's rent in advance, tough poo. This is a big change, and one that people haven't really taken into consideration. And even as an agent, we're still undecided what we're going to do. Because this, to me, is a huge risk. Because if you remember, and if I take you back to some of my basic legal days training that I do, there has to be 3 things for a contract to be valid. There has to be offer, consideration, and acceptance. The offer is the house, the consideration is the rent, and the acceptance is the tenants say yes and landlord says yes. Once that contract is signed, there is consideration, there is an offer, and there is acceptance. They've just failed to pay the rent. Just like if they failed to pay the rent in month 3 or 4 or 5, like we've just talked about in rent arrears, right? But the risk that we're facing here is that actually they could fall into arrears on day 1, because you can't request the rent in advance until the contract has been signed. You have a holding deposit, but what is that? 1 week? You can request the security deposit, absolutely. So the protection that you will have as a landlord is a security deposit, maximum 5 weeks, and a holding deposit of a week. So you will hold 6 weeks rent protection, because the deposit will be protected. You can't use it for rent, and you'll have 1 week's worth of rent. Well, you can't sign a contract without a date, because how do you know what date, what is the start date? What we're trying to do here is exactly what I've done and tried to think, right, how can we get away around this? Because even as an agent, this is scuppering my brain thought process. And there's part of me that thinks, sometimes in life you do have to mitigate your risk or look at, minimise your risk. Are tenants really going to know this? Are they really going to know that they've paid it before? We're just going to have to take a view on it and see how it goes. But the problem really here isn't our fees. The problem is, again, the rule that's been put in place is silly. It's a silly rule. It makes no logical sense. It gives the tenant no benefit. It gives the landlord no comfort. It's a silly rule, but it is a rule. And then another thing just to bear in mind, particularly around rent in advance, is that the tenant, once the tenancy has started, can choose to pay any amount of rent early. So if a tenant moves in and you take 1 month's rent in advance and then they pay you the next 11 months because they know they're going to stay there for 12, that is okay. But if they exercise their right to serve you their 2 months' notice and leave after 3 months, you have to refund all of the rent that wasn't due. As an agent, we're choosing not to go down that route because Do you want to be the example of the first case law that comes from this new piece of legislation? Because I'm damn sure I don't. I'm going to let others make the mistakes and I'm going to watch what happens to them, because this is how law starts to change and how things start to then form more of a sensible path by judicial review and case law. But as it stands, that's the law. That's all I can tell you as of the 1st of May.